This conference will now be recorded.
All right, well, I want to thank you all for joining us this afternoon. Again, this is being recorded, so if you want to go back and check a section out, we'll have this on our website. Now I'll be showing you where to find that on the website when we finish up in a little bit. As we get started, I do want to mention something very important, and it's very relevant to business rights as it relates to COVID-19, and that is Senate Bill 330, the Safe Harbor for Business Act. My understanding is this bill was heard in Senate committee today and passed out of Senate committee. I don't think that it was heard on the Senate floor yet. It is obviously a Senate bill, so it's starting in the Senate. Once it does pass, it will have to go to the House. But this bill will provide some additional protections for business and healthcare providers from the threat of frivolous lawsuits that could be financially devastating to businesses. As it relates to individuals that may contract COVID-19 as employees or as customers in a business. Obviously, it's limited to, the protections are limited, would not apply to those that are grossly negligent. But as we discussed yesterday, there are provisions for what employers can do to provide a safe workplace for their employees and their visitors. But this legislation will provide some additional protections for businesses. If you have a relationship with local Senate, with state senators and state House reps, feel free to reach out to them to let them know that you're aware of the bill and express your support if you so desire. If you're interested in more information on that bill, feel free to reach out to me. I'll send you the full bill if you'd like, as well as a summary so that you can review it for yourself. And so without further ado, let's dive into business rights and COVID-19. We're going to be talking about rehiring after unemployment. I first want to point out and give a special thanks to the Chamber of West Alabama, the Dothan Area Chamber of Commerce, West Alabama Works, Southeast Alabama Works. They put together a comprehensive guide. They collaborated to put this guide together and shared it with us throughout the state. You're also going to be able to have access to that guide, but that guide is what we use to put together this presentation today. A quick disclaimer, obviously all of the information may not be applicable to every business. It doesn't address any health, safety, or workplace requirements prior to the age of COVID-19, and as things evolve, so will public health recommendations and safety recommendations. So this is obviously a point in time presentation. This is what we believe to be good and true knowledge at this time. We advise you that before you make any massive changes to practices or procedures within your own business, that you be sure you consult your own legal counsel, your other advisors. This is a guideline and strictly a guideline. And it's highly unlikely that as this pandemic changes, guidance will change as well. So we will work to bring you the most up-to-date information as it becomes available. So let's start off with this question. What can an employer require from a returning employee? If you have an employee that you feel like needs medical clearance, perhaps they have tested positive, they have a close relative within their household, they've tested positive, you may be looking for some additional security to know that they're safe to return. You can require a fitness for duty statement from a physician for your employee. But do keep in mind that medical offices are overwhelmed. They're just really now beginning to ramp back up with being able to see individuals that aren't at a critical state. And so that may delay the opportunity for that employee to come back if you do require that fitness for duty statement, but you are able to do that. You can also require screening. You can require that an employee be tested, but I do want to point out that test is only accurate at the point of time that it is administered. The individual could literally contract the disease minutes after testing, so it's not considered exceptionally reliable. You could also require that a temperature be taken prior to entering a building. I have heard of some models that are establishing a checkpoint as employees enter. But keep in mind that employee can be completely asymptomatic and still be COVID-19 positive. So again, not exceptionally accurate. One of the best practices that we've seen recommended is self-screening and through just identification of some specific things that you're asking the employee to check. Like, you could even have them complete a questionnaire if you want to. I'm not sure it's necessary to go to that extent, but you can provide a list of symptoms and activities that you feel like are of exceptional risk to your business, to that employee, and ask them to self-screen and identify that they do not have any of these situations. Those can include things like a known exposure, a fever of 100.4 degrees or higher, a cough, a persistent cough, a shortness of breath, an extended period of lost sense of taste or smell, and chills. And asking an employee to self-identify those issues is one of your safest practices. You're not violating any HIPAA regulations. You're asking them to self-identify if they believe they're at high risk. And you don't have to require it. You can just request it. Let me point that out. From the Department of Labor, I want to talk about unemployment. Unemployment benefits of any kind are not available to employees, and this is a question we have received quite a bit. I know there's been some concerns out there that it is not available to employees who quit without good work-related cause, who refuse to return to work when it becomes available to them again, or that refuse to receive full-time pay. I know with the Paycheck Protection Program, there are some businesses that have received loans and have, and I use air quotes, called back employees from unemployment because they now have a loan, and that loan, in order for them to receive forgiveness, requires that 75% of that go to salaries. And so there are some situations where an employee has been called back to receive that full-time pay, but they may be making a little more with the pandemic unemployment assistance stipend than they were previously. That is, they're no longer eligible for unemployment benefits if they've been called back to work, even if they've been called back to full-time pay and they're not required to go into work. So we're gonna get a little deeper into that in just a bit. Refusing to return to available work could result in a disqualification of unemployment benefit eligibility. Attempts to collect unemployment benefits after quitting a job without good work-related cause is considered to be fraud. And the CARES Act specifically provides for serious consequences for fraudulent cases, including fines, confinement, and an inability to receive further unemployment compensation benefits until all fraudulent claims and fines have been repaid. And employers are encouraged to utilize the new hire system to report those employees who fail to return to work. And this sounds harsh. I know there are a lot of employees out there that have some very kind hearts, and they feel concerned. As much as we all are concerned about each other, you also have to be very concerned about your organization, your business, and the longevity of it. This is a point in time that we are very hopeful we're going to get through quickly, and we've got to be sure that we maintain the integrity of our organizations and the financial health of our organizations and the ability for them to exist in the long term. So here are some recommended steps to take if this situation occurs, if you have recalled an employee who does not want to come back to work. Employers should communicate with your laid off employees in as much advance as possible to notify them of their date of recall. If you know that you're bringing them back in 2 weeks, or if you know you've applied for a Paycheck Protection Program loan and you believe your possibility is good that you will get it, it doesn't hurt to go ahead and give them a call and say, hey, I've applied for this loan. When I get it, you need to be aware you'll be called back to work, and explain what those circumstances will look like, so that they have they have advance notice if they need to make any arrangements for their schedules to be able to return back to work. They've had plenty of time to do that. When they're officially recalled, the employer should create a roster including the company name, individual's name, social security number, the date laid off, and the date recalled, and email that roster to newhire@labor.alabama.gov. And we'll look at a sample of that roster in just a bit. There's also an online reporting tool we're going to look at in just a little bit. That's also another option. Employees refusing to return to work should be informed in writing that the Department of Labor has been notified of their offer for available work, and they should be notified by you, the employer, that their unemployment benefits will stop if they refuse the work. We're also going to show you some sample letters that you can send to your employees that will help you document the notification. Do keep in mind that some employees may be willing to come back to work but might not have childcare, and they may be entitled to paid leave. We'll talk about that just a bit in a second. That paid leave, it is there are a couple of different things about that. They are entitled to the paid leave if they have no childcare and they certify that they have no childcare. And that's through the Families First Act. Emergency paid leave is 2/3 of their regular pay. That can be if an employer has not received a Paycheck Protection Program loan, that pay can be recouped through tax credits. You cannot recoup that through tax credits if you've received a Paycheck Protection loan because you have already received coverage for their pay. So you do need to be mindful of that. Some very small businesses may be able to demonstrate exceptional financial hardship if they had not received the Paycheck Protection loan and could not put those wages forward on the front end to be recouped later, and they could get exempted from that paid leave requirement, but they would have to show essentially that they're financially unable to front that pay before getting reimbursed. So what if you have an employee that has tested positive? If they are currently positive, they are known infected, they would qualify for emergency paid medical leave, as we just discussed. What if you have an employee that is quarantined because of exposure? That employee, through trace contact notification, there is a form that you can require that they certify that they have been exposed and are medically quarantined. They would also qualify for emergency paid medical leave. But if you have an employee that is just afraid to return to work or doesn't want to work, outside of ADA protected diagnoses, they must return to work or they could lose their job and their unemployment benefits. And again, I stress that tomorrow we'll be hosting that ADA compliance webinar at 2, and then next Tuesday we'll be hosting an in-depth panel called Pivot Forward next Tuesday at 2. We're going to get really deep, a lot deeper into that from some local experts. So let's look at the online portal. And I'm going to tell you, some of the screenshots turned out great, some are a little fuzzy. I apologize, but I think you'll get the gist of this. This is something we really wanted to share because a lot of times you get halfway through a process and you're not sure which button to click or which whistle to blow and which T to cross and which I to dot, and it gets complicated and you end up spinning your wheels and spending a lot of time. So when you have rehired an individual and or when you have recalled an individual that has refused work, the portal you visit is labor.alabama.gov, and you see here /new hire, new NH /new hire e-file /login. This is available on our website as well. If you went to Google and typed in Alabama Department of Labor new hire, it's going to help you find this link. And this is what the screen is going to look like. You have hopefully used this portal before when you did hire individuals in the past. So this is the same portal you used when you've reported any new hires. So you'll enter your company information and your login. And then on the next page, you're going to check this box. It says you must check below that you've read and understand the changes that were implemented in 2010 and 11, and hit next. You're going to choose your company and click continue. So this is where your company name will show up. So you'll choose that company, you'll click continue. And then on this next screen, this is where you will select enter your new hire information right here. So this is the screen where you'll have your employer's name here and employer's address. This is where you'll enter the employee's social security number and their full name, their home address, and then the indicator. And this is where you're going to indicate whether it's a new hire, you've called them back to work, or if this employee has refused work, this is the area where you would choose work refusal on indicator. So that way the Department of Labor is aware that this individual has been offered available work, but they have not accepted. And then you will enter the activity date. And we point that out because it can be confusing, because you think, well, am I supposed to go to report this as a new hire when this individual is not coming back? They have actually refused work, so I have not hired them. But this is the methodology for reporting even those that refuse work. This is a sample of what the roster would look like for mass file. Hopefully you don't have 50 people that are refusing to come back to work. Generally, you're probably looking at just a couple of them that you're going to have that issue with. I will point out that some of the local HR experts in our area have suggested that even if you do have 4 or 5 to report, it is often a simpler process to go ahead and manually key those on the portal instead of attempting to do the mass reporting roster. They have very strict guidelines on the formatting of the fields, and if it's not just right, it's hard for their system to read it, and it could get sent back to you several times. So unless you just have an exceptional amount to report, in which case you may be working with an HR professional company to help you do that anyway, I would suggest going through that new hire portal. Let's talk a little bit about some sample letters. I want to provide a disclaimer for this. The folks that help put these letters together in West Alabama and Southeast Alabama consulted several employment attorneys and had them reviewed by the Department of Labor. They are not official legal advice. They do not create any attorney-client relationship with any entity. If you have unique needs or schedules or workforce or production issues, it may not apply to your business. You need to use your own business judgment on how you want to communicate with your laid off or furloughed staff. These are simply some guidelines. So we've got 2 letters that could be used to help you with communicating to those individuals who are laid off or furloughed. And you should definitely call and or email, probably call, email, and possibly mail these letters about returning to work. So in the first sample that we're going to talk about, the suggestion is that you send this as soon as you make your initial communication. As soon as you make the phone call, as soon as you send that email, go ahead and get this letter out to them. And it's a confirmation of your instructions that you've given to the employee that the work is available to them on a certain date and your expectations for them to return to work. It also places the employee on notice that if they fail to return to work, their job will be considered abandoned and that you do intend to notify the Department of Labor that they did refuse the opportunity to work. And it's a very simple letter. It can be modified to fit your business needs specifically. You notice that you're encouraging sick people to stay home. You want to put in exactly what your business is doing. If you're implementing flexible or supportive policies, let them know what you're doing to clean your facility and maintain cleanliness and a healthy work area. And then you're going to want to make sure you have specific dates that when they've been recalled and the date that they're expected to be there. It wouldn't hurt to even specify the time. These letters are available for download on our website in Word format so that you can literally copy and paste and modify the way that you see fit. But again, I would caution you to use them as cookie cutters. You need to make sure you read through them thoroughly and modify them so that they fit your specific activities and your needs. So that's the first letter. The second letter is a recommended follow-up for an employee who did fail to appear for work as instructed. And there's even a suggestion that you do send this, even if the employee tells you ahead of time, I'm not coming back, I'm telling you I'm not coming back, you do have to wait until they have not shown to have the official refusal. And so you send this out when they have failed to return to work, and this is their official notification that the Department of Labor will be notified, and that the Department of Labor is able to recoup any money, and that there could be other repercussions for them not returning and or making a fraudulent claim. So this is the second letter. This also is available for download on our website, and I'll show you guys where to find that at the end of this presentation. It is important for you as employers to know that employment compensation fraud is a crime. It carries up to a Class B felony, fines of $500 and 12 months in jail for each fraudulent week claimed, mandatory ineligibility for up to a 2-year period, and there is a 1-800 number for individuals to report suspected unemployment compensation fraud. Just so that you're clear on some examples of fraud, obviously making false statements to obtain unemployment compensation, attempting to draw benefits while working, continuing to file a claim after returning to work, being paid under the table while collecting unemployment compensation. Let me point out, for those that have received Paycheck Protection Program loans, you're going to need to be able to quantify the funds that you have expended on payroll. So hopefully no one would ever commit something like paying under the table in cash, but you definitely want to be cognizant you wouldn't be able to get those payments quantified, so you wouldn't be able to have that amount forgiven. And as well as not being truthful when filing your initial or weekly claims. So that would include those false statements, and then not being truthful when filing that weekly claim. If they certify the week after they were supposed to return to work that they did not have work available to them, they would definitely be committing unemployment compensation fraud, because they're certifying that they were not offered work when they in fact were. So a couple of resources available to get some additional information. The Alabama Department of Labor obviously has a wide array of information, as well as the U.S. Department of Labor has a lot of information on the Family First Act and the CARES Act. And then we also, as I mentioned, have a lot of downloadable resources, and I wanted to kind of show you where you find those. I'm going to move our website over here. The first slide that you see on our website, Restart Etowah, this is our comprehensive repository, I guess I should say, for all activities related to how we're working to serve you to get our economy restarted and help businesses get back to business. And so you're going to see a great deal of information, including, this is the webinars and surveys sections. If you're looking for a recorded webinar, you can click here. It will take you to a different page, and you can search through those. You can see all of our upcoming ones. But if you go to assistance programs, and this is going to be assistance to businesses primarily, with closure orders, the business financial assistance, you'll click on unemployment information. It'll scroll down to an anchor on the page. It has information on how to file for unemployment, for employers for themselves, for them to help employees if they need to. It gives information about unemployment expansion for furloughed employees. That includes the pandemic unemployment assistance program. And then you will see this business rights in COVID-19. And this is the document that I referenced earlier, compiled by these great folks. You can download this. It's a PDF, and get this information that's been presented today in a paper format. And you can also download these sample letters. You click that, it downloads a Word document. And you'll see that this specific one is watermarked, so you would want to scroll over, copy, and paste it onto your own letterhead. Make sure that you've made changes as appropriate to your specific business before sending it. So at this time, I'm looking at chat. I'm not seeing where any questions have been submitted previously. If someone does have a question, you can feel free to unmute. We'll give you just a few minutes to ask. I'm not saying I might know, but I did see Mike Perkins join the call, so he might know if I don't. Does anyone have any questions? Okay, well, if not, again, I want to remind you about Senate Bill 330. If you would like to check that out, I can send you a copy of it. Again, that is the Safe Harbor for Business Act that would provide some protections for businesses related to frivolous lawsuit claims related to COVID-19. And I also want to remind you of the other upcoming webinars that we have for this week and next week. We are, some of these we're trying to condense down to 30 minutes. We know you're busy. We know you're probably webinared to death as well. So we're trying to get them shortened and condensed so that they're digestible and tolerable. I want to remind you that we are here for you. If you have any questions, if you need to give us a call, we're back at the office. We've never stopped working. We had our phones forwarded there for a while we worked remotely, but we are back at the office, and this is our main priority is you. So if you would like to give us a call and let us help you just talk through a situation, see if we can find the resource for you or the answer for you. It is our honor to do so. Have a typo here in my telephone number. How embarrassing is that? Obviously, there's no 3 between the 6 and the 5 of 256-543-3472. You can shoot me an email. We are not open to the public right now. If there's a situation where you really just need to meet in person, you can call and make an appointment. We can let you in. We would ask that you wear a face covering and use our hand sanitizer that we'll provide, and we will meet with you in one of our large conference rooms so that we can maintain social distancing. But most everything we can help you over the phone. We can help you by email. We can jump on a go-to meeting with just the two of us and talk a situation through. If you have ideas on any information that you would like for us to present on, please feel free to send us those suggestions. And then once more, I'll remind you, this was recorded. So if you do need to go back, if you missed the very beginning or anything like that, you can go to our website, go to those recorded webinars, and find it in about 15 minutes. Thank you guys for being with us. Hang in there. We're here for you. Just give us a call if we can help you in any way. Take care.